This lecture deals with chapter 2 of the textbook, which covers the subject of legal ethics. I'm going to break up the chapter into two separate lectures. This is obviously is the first one. As the textbook accurately points out, in popular media, attorneys are often referred to as things like hired guns, mouthpieces, things of that nature. The lawyer joke goes, how do you know when a lawyer is lying? Answer, his lips are moving. So the question is, why do we think there's such a negative perception of lawyers and what they do? Or perhaps is it a fair characterization? Many people argue that lawyers get a bad rap because the public associates them with the clients that they represent. For example, if the lawyer represents the Ku Klux Klan for its right to march in a parade, the public is likely to see the attorney as being a supporter of the beliefs of the Ku Klux Klan, rather than being an advocate for free speech. This happened in the famous case of when the ACLU represented the Ku Klux Klan and defended their right to march in Skokie, Illinois, which was a heavily Jewish neighborhood outside of Chicago. Again, the ACLU was, really criticized harshly by because of their actions, people thinking that the ACLU was actually supporting the Nazis, when in fact the ACLU was arguing for free speech. All right, case number 3 in the textbook, the ethically challenged paralegal, is really an interesting study. It begins at page 26 of the textbook, and I highly recommend that you look at it because a lot of the things that are raised in that hypothetical fact pattern apply to what we're talking about here. We got 4 people involved. John Bloom, who is a lawyer, Sally Green, who is Mr. Bloom's paralegal, Sarah Smith, the client, and Bertha, who is a friend of Sarah. And the hypothetical starts out with the fact that Sarah served a pot roast to her family, and they all got bad stomach cramps and diarrhea. And an ER doctor told Sarah that it potentially was a case of food poisoning. So she comes to lawyer Bloom, and they discuss filing a lawsuit against the grocery store. Like many, in fact, probably the overwhelming majority of all personal injury cases, Mr. Bloom says that he would consider taking the case on a contingency fee basis, meaning that he would get 1/3 of the recovery, but he first needed to do some investigations. So Sally Green, the paralegal for Bloom, then calls the grocery store and falsely represents that she's from the health department and asks about complaints about spoiled meat. So question, do you have any problem with the paralegal lying to the grocery store and stating that she's from the health department? Bloom, later on in the week, lawyer Bloom has to meet payroll and doesn't have money. So he tells Sally Green, the paralegal, well, just go ahead and write checks that are on our, and have them drawn on our attorney-client trust account. Because we don't have enough money in the general account, we've got to make our payroll. Bloom assured Sarah that not to worry, that there would be money coming in by the end of the week, and they could put it back in the trust account. So again, the next question is, do you have a problem with borrowing money from a client trust account? Bloom later told Green that he had a whole bunch of documents that were on his desk that needed to be notarized, and asked her to go ahead and notarize the documents. Again, presumably without observing the signature. So should the paralegal be able to rely and follow the directions of the lawyer? Later in the day, the fax machine at the receptionist desk spit out a fax from another law firm, and the receptionist took the fax to Green. The fax was from an opposing law firm, and it had been mistakenly sent to the Bloom firm, and the fax should have gone to that law firm's client. And again, that law firm and the client were adverse to the Bloom firm. So Ms. Green reads the letter, says, "Hey, great, this has got helpful information." And in fact, it went so far as there was a cover sheet that said it was attorney-client privilege information. So the question is, should the paralegal have read the letter? And if so, is the Bloom firm entitled to rely on things that they learned reading this misdirected letter? Finally, the hypothetical talks about Ms. Green discussing cases with her husband over dinner. And the question is whether there's any problems with this. So again, these all raise issues, legal ethical issues that we'll be talking about in the course of Chapter 2 of the textbook. The overriding legal maxim that governs lawyers, or that lawyers should aspire to, is set forth in the slide, that the lawyer should avoid even the appearance of professional impropriety. So a lot of the things we talk about relate back to this doctrine. And again, if you look at the hypothetical, there's not much in there that doesn't reek of impropriety. The text has a discussion about regulation of paralegals, and it points out that we're really talking about the regulation of the legal profession in itself. There are no state laws right now that actually regulate or deal with the ethical issues related to paralegals, other than things that we talked about in connection with Chapter 1 and the definitions of paralegal and what paralegals are allowed to do and not allowed to do. But there isn't a set of ethical guidelines that govern paralegals. Instead, they are required to follow all of the ethical rules that apply to the lawyers that employ them. There are trade groups, including NALA, or the National NFPA, that have ethical codes for members of those organizations. But it should be pointed out that these are voluntary and not mandatory. Most lawyers in the United States are governed by the American Bar Association's model rules of professional conduct. They've actually been adopted in every state except one, that's California. The ABA model rules are not binding on California lawyers. Instead, California has its own rules of professional conduct, which recently were amended to closely follow the ABA rules. In fact, they have the same numbering system, meaning that the California rules of professional conduct number corresponds to the ABA rule number. But the important thing to note is that the rules aren't necessarily the same. So just for instance, one rule, ABA model rule 1.8 and California rule of professional conduct 1.8 both deal with the same issue, but they may come to completely different results. So again, California lawyers are governed by California rules of professional conduct, And in turn, the paralegals that work with those lawyers are required to comply with these rules of professional conduct. And again, the ethical codes governing paralegal conduct are do not exist outside of the paralegal associations. The three major things that make up the legal rule of ethics, or the legal concept of ethics, deal with client confidentiality, number one, two, conflicts of interest, and three, the unauthorized practice of law. Again, we talked about unauthorized practice of law in connection with chapter 1 of the textbook. I'm not going to spend a lot of time on it in the lecture here. It is covered by the textbook, and I expect you to be fully familiar with it. The rule of confidentiality is actually essential to the legal system. It's based upon in part on the fact that the lawyer must know all of the facts in order to give a client effective legal advice. If a client is or fails to inform a lawyer of all of the facts relating to a case, or is afraid to do so, the lawyer is not going to be able to give competent legal advice. This is in the same way that doctors have to know everything about their clients' symptoms, and we have the same confidentiality rules that encourage a patient to disclose things to a doctor with the idea there'll be protection from confidentiality. So we have two separate areas that deal with confidentiality. One is ethical rules that prohibit attorneys and paralegals from disclosing information. And second, the attorney-client privilege. And as noted in the attorney-client privilege, that is the rule of evidence that prevents an attorney or their employees, i.e. a paralegal, from being compelled to testify about confidentiality. Now, confidentiality, again, is extremely important, and it applies to current clients, potential clients, and past clients. So if a client interviews a lawyer, and for whatever reason, the lawyer either doesn't take the case, or the client agrees or decides not to hire the lawyer, nevertheless, anything that was disclosed in that meeting is subject to the lawyer's rule of lawyer's obligation of confidentiality, even though the lawyer may not have been hired to represent the client. This extends even to the fact that a lawyer actually represents somebody. I have a good friend that's a criminal defense lawyer, and one of his clients is one of the local archdioceses. And he brought this to my attention, that he couldn't even disclose in any kind of conversation that he represented any particular person, particularly a priest, because people would automatically assume that, hey, he's a criminal defense lawyer. He represents this priest. Obviously, this priest must be a sexual predator. And again, one of the things my client pointed out, that the vast majority of cases that are referred or that the DA reviews for criminal prosecution, there's no criminal prosecution brought. So if it was known that he represented one particular priest, again, that could be incredibly harmful to the priest, who may not have any liability. So again, confidentiality important. And this obligation of confidentiality applies to people that work in the lawyer's office, including secretaries, file clerks, paralegals, etc. There is one exception to the confidentiality, and the nature of the exception depends upon what state you're in. But it's a situation where a client comes to a lawyer and discloses that the client is thinking about committing a crime, or again, prospectively will be committing a crime. So the question that the textbook raises, and it's an excellent one, is: do you think there are any instances when reporting, a lawyer should be required to report or reveal a client's planned crime? And again, the basic rule depends on what state that you're involved in. Is basically in nearly every state, a lawyer has the ability to report potential violent crime. And again, it depends upon the state whether or not there's financial crimes can be reported. So again, you have to evaluate the nature of the crime, and then or the threatened crime, and then research what the appropriate state law is. And there's a kind of a hierarchy of criminal matters that are set forth in page 34 of the textbook. You can take a look at that. Just for your information, the California rule is very, very limited, and it does not require a lawyer to report potential crime. And again, it says a lawyer may, but there is a number of exceptions to that. And again, this can be contrasted with the majority rule in most jurisdictions that would require a lawyer to disclose a potential crime. And in some jurisdictions, even if it's not, doesn't involve bodily injury. One of the things that's related to confidentiality is if a lawyer has, by mistake or inadvertently, disclosed confidential information of a client to another side. And this could happen, the text points out, in many instances. Sometimes it's just an error, like in the hypothetical about the facts being sent to the and the receptionist read. But so the issue becomes if a lawyer receives documents that clearly they shouldn't have. They may have been governed by the attorney-client privilege, or just simply inadvertently disclosed. Can a lawyer use those things, and what are the lawyer's obligations? And it basically, as the text points out, if an attorney receives information that the other side accidentally sent, the lawyer, there's really four things that they can do. One, they can not read it and then contact the opposing lawyer and return the information. This is kind of unrealistic, because how are you going to know it's confidential if you haven't read it? Second is to read it, then contact the attorney and return the document. So again, that's probably more likely. Third is to read it, contact the other lawyer, let them know that you received it, but basically say, look, I've received it, I've read it, I just want to let you know that I've read it, but I'm not going to return it to you. And then finally, just not not inform the other lawyer. Read the information, use it as part of your case. So the question is, given the fact that we have an adversarial system of justice, what do you think is the appropriate rule? What should a lawyer be required to do? And again, you kind of put yourself in a position is if you were put yourself in the shoes of the lawyer that mistakenly disclosed the information. Now, I can tell you that in the real world, I think most of the time lawyers are going to read the stuff and use it, and whether or not they report it is problematical. The textbook poses a hypothetical that what would happen if an attorney, plaintiff's attorney, is representing a plaintiff in an automobile accident, and she's talked it over with her client, and they've decided that they would settle for $200,000, and they're getting ready to go into a mediation to negotiate a settlement. As the lawyer is preparing for the mediation, she discovers a fax that had been mistakenly sent to her, and the fax was from the defendant's insurance company sent to the defendant's lawyer. So again, the fax was sent to the other side, and the insurance company tells the other lawyer that, look, try to settle the case for $100,000, but you're authorized to settle it for up to $500,000. So the question is, what ethical obligations does that plaintiff lawyer have in that situation? The answer, at least in California, is that the plaintiff's lawyer is required to take advantage of that. The plaintiff's lawyer has an obligation to represent her client to the best of her ability and get the highest possible recovery for that client. So, and there was a California Court of Appeal case, Aerojet General Corporation versus Transport Indemnity Insurance. It's a Court of Appeal case from 1993 that said, there's a quote, once he has acquired the information in a manner that was not due to his own fault or wrongdoing, he cannot purge it from his mind. Indeed, his professional obligation demands that he utilize his knowledge about the case on his client's behalf. So again, the key issue in that case appears to be that the lawyer didn't do anything wrong, and again is in fact required to utilize the information. The other issue, again relating to confidentiality, is the attorney-client privilege. And the attorney-client privilege is a rule of evidence that prevents an attorney or any of their employees, including a paralegal, from being compelled to testify about confidential client information. This, again, encourages confidentiality between lawyers and clients. The attorney-client privilege is not absolute. And one of the things that we keep in mind is that it only applies to confidential communications. So if we go back to the initial hypothetical that started off the chapter, you remember that the client brought along a friend to the initial meeting. And that raises the issue whether this was in fact, what was discussed in there was a confidential communication. The friend is not a client, not a spouse. And I would argue that those the conversations that took place were not protected by the attorney-client privilege because of the existence of the friend. Again, it has to be a confidential communication. So if a lawyer writes a long opinion letter to the client, setting forth the lawyer's analysis of the case, arguing the strengths and weaknesses of the case, most lawyers will write all over this is attorney-client privilege communication. Do not disclose to anyone. You might even have a footer on every page of the letter. So what happens if the client takes that letter and shows it to their friend and says, "What do you think?" Again, the attorney-client privilege in that situation probably does not apply, and the client would be held to have waived it, and that letter would be admissible. So again, going back to the ethical issues we're talking about here, we've talked about confidentiality. The next issue that comes up in conflict is conflict of interest, and I'll discuss that in the next video.